is governed by the Work at Height Regulations 2005, often seen as WAHR or WAH. The purpose of the regulation is to prevent death and injury caused from a fall from height. Employers and those in control of any WAH must ensure work is properly planned, supervised and carried out by a competent person. Employees have general legal duties to take care of themselves and others who may be affected by their actions and therefore cooperate with their employer. The dangers of work at height. There is no limit for work at height. Work at height can occur at any height, not just extreme elevations. The consequences can be very serious and can result in death or life-changing injuries. Falls can occur from relatively small elevations and often occur because the person does not deem the hazard to be significant or see the potential risk as the height seems to be low. Frightening facts! The majority of the falls are below 4 metres, which is far enough to sustain an extreme injury or even death. A third of all work-related fatalities at work are work at height, which is the second biggest cause of accidental death. When talking about work at height, people automatically assume ladders are involved. But ladders should not be used as a workplace. Ladders should only be used as an access and an egress. For example, scaffolding. If you must work on a ladder, then all work must be limited to a maximum of 30 minutes. All work should be risk-based, well-organised and planned in advance. There is a legal requirement to complete a risk assessment for all work at height. If you employ more than 5 persons, you should keep a written record of all risk assessments. If employers fail on their legal obligation, they can face prosecution under criminal law. In addition, employers owe a duty of care under the civil law. This means that they could be liable to pay out compensation to the injured parties or their relatives.